when discussing with you, Cole, and I think it's an opportunity again to thank you for this great event, the terms of my own participation to the conference, we agreed that I would very briefly share some of the findings of a recent European research project. And by the way, I'm speaking under the control of many partners in the room. The project was called religare, which is the Latin word for binding people, and was on purpose also chosen for this reason. That gave us the opportunity to assess how in Europe, and we focused on 9 countries and we included Turkey, religion, and more particularly the protection of it, is addressed when it comes to prepare the future of democratic and hopefully prosperous societies. Now, speaking on a panel that links religion, freedom, and economic development, that is the title of this panel, gives me the opportunity to follow on what was very clearly underscored by various speakers at the dinner yesterday evening, and in particular by Ambassador Superstadt, when he said sustainable development and consistent respect for freedom of religion and belief go hand in hand. Now, yet against the background of increasing and not to say extreme tensions among faith-based communities in the Middle East and now more recently the challenges with which also other states in the world, and in this case I will deal with Europe, are faced when having to deal with some of the dramatic consequences of these tensions, one is bound to acknowledge that this close bond between openness to religious diversity and sustainable development is put at risk, not to say under threat. Now, there was a call from the European Commission in 2009. It published a call and a proposal sounded secularism and religious pluralism. Now, it was, and I will phrase the mandate in the following way so it makes clear what was the mandate, is to address how the interplay of religious and secular laws, values and practices influence public policies, so the bottom-up approach, as well as the impact of these laws, values, and practices on the behavior of individuals and groups, and whether these policies create opportunities in public and private life. This, of course, equates a huge mandate. We could not cover everything, so we chose to focus on 9 countries plus Turkey, and we really digged into 4 areas of participation in society, which is access to employment and participation in the labor market, family, public space, and state support to religions. By the way, the report which we submitted to the European Commission was sent so everybody had a chance or can, if wanted, read the text of it. Now, very briefly, what all these countries have in common is the option just to deal with religious diversity within the framework of a secular state. And this secular state is very often also constitutionalized. It may take different forms. It may take really the form of clear separation, which is la France laïcité. It may also be the Turkish secular state, but then with its own developments. In some countries, you have arrangements like the Church of England with the constitutional mandate that it has within this secular state. And then you have countries where the kind of secularity is phrased in terms of neutrality. The state has no religious identity, but it deals with religions on a footing of equal treatment. No? So this is the neutrality. Now, the aim of religare has been to compare the various ways in which this kind of secular state deals with the protection of religious diversity. And as I said, we focused on 4 areas, and what we did is we did it through concrete cases where you see in each country major conflicts revolving around religion and this secular state. And we did it, for example, for religious symbols in the public space, state support to religious education, religion in the workplace. And the goal has been to see whether between the principle of the protection and the implementation of the protection, what is the gap and who is filling the gap. And we did it on an interdisciplinary base, which is we did not limit ourselves to digging into the case law. We also interviewed people who are closely linked to religious minorities or to philosophical convictions, faith-based, non-faith-based, how they perceive the way the state is dealing with this diversity, whether have other expectations, whether they... Should I from time to time touch the screen? Well, by the way, I really wanted just to have the Religare project mentioned there, but as I said, the report is being distributed. Now, what you really kind of get from this kind of comparison is, in fact, a number of kind of conclusions that you can draw. I wonder whether I have time to just go into some of the convictions that we had, for example, for family law. Once you think of Europe as a country where the people have their own backgrounds, but you cannot consider their backgrounds any longer as from migrant origin. People have their religious conviction. People want to live conforming their religious conviction. Aren't there legal techniques that would allow people in a secular state to come closer to a family life that is being granted some recognition also in this religious dimension? Contractual law, for example, or when there is a problem of tension in families, a kind of arbitration or mediation within the religious community. All these things are perfectly marriable and are perfectly kind of incorporable in a secular state logic, but you have to think forward. You have to think about the future of society. And the next panel, I think Cathy Alidadi is moderating a panel where we have been doing exactly the same for employment. If you want, it is perfectly doable under a secular state law regime to stay open for religious diversity in the workplace. Now, it will, and it brings with it the major challenge that you need really this willingness to look for pathways to think of a different future. And this is what brings me to what is ongoing these days in Europe. When you read the newspaper this morning, when you are these kind of frightening questions, are we now paying the price for having excluded new minorities? Are we paying the price that we satisfied with formal equality, which is the laïcité, and not going beyond to substantial equality? Well, the answer is we have to do it. If then not yet, then we have to do it for the future. And it is exactly what the Religare project tries to come up with, ideas to think in the long run. For lack of legislation, what we did is we digged into the case law, and some case law is extraordinarily creative. The problem is it's inconsistent. It's not kind of very visible, and we depend on judges. In fact, we expect the judges to do the work that the legislators should do. So that is a forward way of thinking. Yes, the case law has solutions, but it should not be the judges to come up always with the solutions. When you think of France, when you think of the reaction of some people today to say, well, if this is the way that we have been dealing with minorities, we should go much more forcefully for the laïcité. Is this the right legislative answer? Laïcité is indeed a way to phrase state neutrality, but you should accompany laïcité with really substantial equality, opportunities for people to participate in society, and then probably laïcité will not be kind of experienced as exclusion, but as in its way, the French way to include. In the panel on employment, what we identified within Religare is a number of what we call good practices, reasonable accommodation. Employers are extraordinarily creative in trying to include people by looking for reasonableness in accommodating diversity. So by giving visibility to some practices, you are also thinking in a forward-oriented way of thinking. But all this would need to be more kind of structural. And here is the task for legislators, to think of the future is to think of more sustainable solutions or more structural solutions. And maybe the good news after this kind of a bit, well, pessimistic is not a word, but the answer so far is not structural, is the last kind of opportunity I had to speak at European level was on the 1st and the 2nd of October. The European Commission held its first annual colloquium on fundamental rights, and the title for this first one was Tolerance and Respect, Preventing and Combating Anti-Semitic and Anti-Muslim Hatred in Europe. And the Commissioner for Employment, she really was very formal in her promise that she would really work on the legislative instruments, those that are already available, which is the Anti-Discrimination Directive of 2000, but also the new one, which is pending since many years, which would open up the anti-discrimination, also the anti-discrimination of religious faith belief for all services, not just access to employment, which is broadening up. It's very controversial. It has pros and cons, but the willingness of the commissioner is a clear signal that she would not leave this opportunity. at the same kind of colloquium, there was a whole kind of discussion on whether we should not use Article 17, which is the kind of, on the one hand, the obligation for the European institutes to respect the constitutional models when it comes to respect of religion and belief and the diversity, but on the other hand, the obligation for the Commission to have consistent, open and regular discussions with religious groups in the European Commission. This is really a kind of bottom-up democracy possibility to listen to the aspirations of these communities that are now part integrally of Europe. So I think if we think of a sustainable development, probably it's a very demanding policy to set up, and when I rethink of what we have been observing in Religare, which is a lot of creativity, but very much ad hoc, also invisible, and a lot of kind of inconsistencies between the principles and reality, I would just sum up in terms of what would be a more substantive inclusion